Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your guest host, Matthew Bruckner, an associate professor at Howard University School of Law. My guest today is Kara Bruce, professor at the University of Toledo College of Law. Kara, welcome to the show.
Thanks so much for having me.
I'm so glad you're here. I really liked your article, Bankruptcy's Adjunct Regulator, with Alexandra Sickler, and so I'm delighted that you agreed to join us. Thank you.
Yes, and I appreciate your feedback that you've given me before, and I'm happy to answer any questions you have.
So I'd love to just start with having you sort of tell us a little bit about the article, the sort of elevator pitch, so to speak, and then we can sort of dive deeper on issues as we get into things.
Okay, great. Well, to begin with, the paper explores the regulatory potential of the Financial Protection Bureau in bankruptcy. So to understand what we're doing here, I think it's important to start with the problem that we've observed and written about in our prior solo work. And the problem is that certain large creditors have found that they can profit from widespread but small scale in any individual case misconduct. So creditors in bankruptcy sometimes profit just through sloppiness and corner cutting. So they're not doing everything they need to do to comply with bankruptcy procedure. And other times, some creditors are outright overreaching. They're extracting more than their fair share from the bankruptcy process. So we can talk about this more later, but there are a variety of reasons why this type of behavior slips through the cracks in bankruptcy. And we argue that the CFPB is really well positioned to serve as an additional check on that type of behavior. So to support that claim, we kind of have two parts of the article, two contributions. The first half of the article is descriptive. It describes how the CFPB's regulatory authority sort of naturally carries over into these bankruptcy matters. I think that really disturbs the notion that bankruptcy is its own sort of self-contained unit. And then we consider in the second part how we can tap into that overlap and build modest, what we believe are common sense regulatory strategies.
That's great. Yeah. So I read the article. I really liked it. I thought that made great sense to me. As you know, I'm in the midst of applying for tenure, and I've been thinking a lot about how I might choose to spend my post-tenure career, assuming things go well. So I was really interested to, this is a topic that you've written in before, and Alexandra has written in before. Just curious. Why this topic? What makes, you can write about whatever you'd like. What makes you passionate about this topic in particular?
Oh, well, that's a fun question to answer. I really like this topic because it allows me to continue to write about something that troubles me, which is this sort of widespread misconduct in bankruptcy. I've written about this for a lot of years. I keep thinking I'm going to move on, but then something else happens. I read about a new line of cases and I get all riled up again. And so then I dive back in using a different dimension. This article is a little refreshing to me because all of my prior work has really focused on private claims and how litigants like the debtor and the debtor's attorney and maybe the case trustee who's involved in bankruptcy cases can police misbehavior. But here, we're taking more of a public regulatory solution, or we're exploring that. And I think that's fun. I think it's unexpected. When you think about the CFPB, you don't really think of it carrying over into the bankruptcy process. So I like that dimension of it. And it just gives me an ability to try to continue to find solutions to this problem that really troubles me.
Mm-hmm. Yeah. Your article focuses on the Bureau, the CFPB, as sort of a bankruptcy regulator, as you call it. And so you talk about, in the piece, you have the descriptive element and a more normative element. So I was just wondering if you could sort of, give us a little bit more of the detail. So what is the role the Bureau currently plays, and what is the role that you envision for the Bureau to be playing in the future if you had your druthers?
Sure. So that is, it's a big question, and I'm going to carve out one kind of elephant in the room and not talk about it I hope that's okay. I'd like to just sidestep the whole political dimension of the CFPB right now. I think most people who are tuning in probably know that under the current administration, the CFPB is not really um, doing exactly what we might expect the Bureau to do in under optimal circumstances. So if we can just focus on maybe what the Bureau historically did or what we might expect of the Bureau, I think the idea is that right now they regulate things like mortgage servicing, payment processing, debt collection. And those very same creditors who are collecting consumer debt outside of bankruptcy are still collecting debt and interfacing with debtors when the debtors enter bankruptcy. The relationships between those parties have not changed, have not stopped just because a bankruptcy case is filed. On the contrary, now the relationship has become just way more complicated because bankruptcy, as you know, is so procedurally rigorous. So I think where the Bureau is regulating right now, they're doing it in sort of a careful, maybe reactive way. So when they're issuing rules that affect bankruptcy, they're trying to sort of harmonize the rules so that they can regulate conduct and not run afoul, have creditors run afoul of bankruptcy law when they're trying to comply with this consumer protection regulation. And supervision and enforcement, when the Bureau's engaging in these types of behaviors, maybe they'll sweep some bankruptcy-related behaviors up when they're looking at misbehavior more broadly outside of bankruptcy. But what we do not see, and what we would like to see, is just a subtle shift in priority, where when the Bureau is going out and exercising its statutory authorities, it's got the bankruptcy implications of its conduct squarely in focus. So, that can be information gathering, where they're thinking through the bankruptcy issues that are coming to the fore, and gathering information and maybe sharing that information with the United States Trustee Program or other bankruptcy regulators, so that bankruptcy regulators can do their job a little bit better. So that's a big aspect of it, just the information gathering. And then when they're just going about their business, sort of shifting, or at least considering the bankruptcy implications of their work.
I was wondering if you might give sort of like a really concrete example from debt collection or mortgage servicing, or something that where the Bureau has been a little bit more reactive in their current or historic regulatory approach, but that you would like to see them be more proactive. So if you could make it maybe a little more sort of concrete for the listeners.
Sure. So I'll give you I think a good example is CFPB's enforcement activities. They've taken many enforcement actions against creditors for a variety of problems that these, misconduct of these creditors that includes bankruptcy misconduct and non-bankruptcy misconduct. And I'm thinking of one consent order in particular with various debt buyers that was written in very expansive terms, where you could see the Bureau was trying to get the debt buyer to agree not to collect stale debt for which the statute of limitations has run by any means. So the consent order is super duper expansive. But doesn't squarely consider or address bankruptcy debt collection or filing claims in bankruptcy. And so arguably that's leaving an escape hatch open that creditors might seize on. So when the Bureau is engaging in these types of efforts, when they're reaching consent orders, or when they're drafting regulations, if they know the bankruptcy sort of landmines and can draft around them, then I think we'll close some of those gaps and prevent that type of misconduct from springing up in its wake.
Thank you. That's
Sure.
really helpful. And sort of flows, I think, nicely to the next question, which I had, which was that, you sort of note in the article that that bankruptcy's existing regulatory regulators are often unable to tap in what you call negative value bankruptcy misconduct. So I was hoping you might sort of talk a little bit more about who are or have in the past been the sort of the bad actors in bankruptcy cases, and talk a little bit more about this misconduct that you're worried about, and then to sort of transition to talk a little more about so the CFPB is not the only player. You've talked about some of the other members of the bankruptcy regulatory team or apparatus, and so why haven't they been up to the task?
Yeah, so that's a great question, and it's really at the core of this article. Why are we looking beyond bankruptcy for a new solution? And the answer is that the bankruptcy structure is not set up to deal with this type of widespread and pernicious misconduct in consumer cases. So, plenty of people violate.
Which has been a real theme of your work, I feel like.
I know. I should branch out, but I just can't. I like it so much. And I guess I do branch out. These days I'm writing a lot more for the bankruptcy law letter. So that gets me out of my core focus. But yes, I do. I always come back to this issue, and I find it arises in a lot of different contexts, and always gives me a new sort of remedial issue to talk about. So yes, still beating this drum so many years later. Okay, so we have plenty of people violate bankruptcy law. My focus is on creditors. These are often repeat players, creditors who are involved in hundreds or thousands of bankruptcy cases and subtly drawing more than their fair share. Bankruptcy's existing regulators, I would count the debtor and the debtor's attorney in that definition. Also, the case trustee, who is somebody who sort of administers bankruptcy cases and tries to maximize the value of the estate for unsecured creditors. So, case trustee is there, and in theory should be looking at addressing conduct where one creditor is overdrawing. The United States trustee. Oh, sorry. Go ahead.
Yeah, if I can interrupt you for a second, can you say more about how they overdraw? I mean, especially for non-bankruptcy people, I feel like they may think, I'm entitled to everything that my contract provides me to. What does it mean to sort of overdraw your fair share in this context?
Yeah, it's so it can be all different types of things, but where you see this come up, let's see. Proof of claim problems are very rampant. So creditors are file proofs of claim that are not procedurally perfect. So they're missing documentation. Maybe they're false. They don't accurately. They don't claim things that the creditor's entitled to claim under law or under the terms of the contract. So that's a big example. Automatic stay and discharge violations. Now we're getting into the weeds of bankruptcy practice, but basically this is collecting debts that bankruptcy law says for various reasons can't be done at that particular time or ever again. So these are the types of things that creditors can do to overdraw. Sometimes it's just adding an improper fee or claiming interest when they're not entitled to. Sometimes it's just economizing and not paying somebody to sign a document that they have to sign under penalty of perjury that it's true and accurate. They're robo signings. So things like that. It can come up in a lot of different contexts, which is why that's why I kind of describe it more generally for this type of thing.
Okay.
So
Thank you.
that's the kind of conduct I'm worried about. And there are a bunch of parties in bankruptcy who potentially could be dealing with it. And I think the challenges that these parties face, again, we can get into the weeds of that. Some of them are specific to various parties, but if we're generalizing, the challenges are first economics. These harms are often very small; they're dispersed, but the gains to the party who's overdrawing or just sort of under complying are pretty pronounced. And so, that's the negative value thing, the idea that a lot of these harms are so small that nobody would actually go to the trouble of litigating them individually. You add to that the reality that bankruptcy professionals carry massive caseloads, which they handle based on economies of scale. So that just makes it hard. And I know you've addressed these kind of incentives in your crowdsourcing piece and some of your other work. So yeah, that's one big challenge. The other challenge to addressing this behavior in bankruptcy is structural. And I think there are two structural issues. One is that the bankruptcy system is not really set up to gather information on sort of a market-wide basis. When you think about the powers that bankruptcy courts have or the U.S. trustee program has to gather information, it's really based on sort of a litigation style framework. So it involves parties to the case at issue. And if that's a class action, that's one thing, but usually there are more individual cases or just a handful of cases. So we don't have that sort of market-wide information gathering potential that the Bureau can bring to the table. And the other structural challenge is just remedial. Bankruptcy's remedies are also not calibrated to police misbehavior on an aggregate basis. And when we've seen case law where judges and other parties have evidence that a creditor is doing something improperly in the case before them, in 1,000 other cases in that district, their efforts to craft a solution that goes beyond the case in front of them quite frequently fail. And some of that has to do with the fact that bankruptcy judges are Article I judges, and some of it has to do with just the remedies in the code and the procedural rules, but it's a really difficult nut to crack within bankruptcy. So that's why those are the areas where I think a more public regulator like the CFPB can really add some value, because that's what they're about, that sort of market-wide information gathering and crafting in enforcement responses that are also sort of market focused.
Absolutely. I mean, in you saying this, it really struck me that that these problems are not, in many ways, bankruptcy-specific problems. I mean, the problems you're talking about in particular arise in the case of bankruptcy, but the instance of creditors asserting sort of small dollar claims against thousands or even millions of consumers, none of which have any incentive to litigate over a $50 fee. Are just the sorts of claims that have been plaguing consumer advocates in other
Sure.
contexts, and I think in many ways really sort of justified or was the basis for justifications for bringing the Bureau into existence in the first place. And so, right. So, my question may have been, although I may have sort of, well, that's my take, and so I'd love to hear your take. Why is the Bureau sort of best suited to sort of fill these gaps in sort of bankruptcy in particular? But, and I think especially since you note that at the start that the Bureau's willingness to engage in sort of proactive consumer protection, what the right word is, right? Really, the best sort of ebbs and flows with who is in the leadership role at the Bureau, and so why are they the best solution here?
Yeah, so that's a great question, and I love the way you characterized the role of the Bureau and sort of how it came into existence, the types of problems it was designed to solve. That's really kind of underlying the shift that we're hoping this intersection of consumer law and bankruptcy law takes, where we can recognize that just like outside of bankruptcy, The bankruptcy system was not really designed with this type of behavior in mind, and this agency really is well suited to address exactly this type of widespread pernicious small value behavior. Now, why do I think they're best suited? And even with the political issues that I tried so hard to avoid, yeah, it's a fair question. Here's what I have to say. The problems that I worry about and can't stop writing about are pretty deep and pernicious, and I think they require a variety of different techniques to address. So I don't think the CFPB is a solution that excludes other regulatory responses. But why I like it is that it has almost immediate, putting aside political realities, very near-term feasibility. We don't need Congress to act and bend over backwards to create this as a solution. All it takes is a subtle shift in priority. I mean, the CFPB already has the authority to regulate these types of debt collection activities. They're already deeply involved with certain companies who are misbehaving in bankruptcy. And so if they are thinking about bankruptcy, if they hire staff members who have bankruptcy training, if they develop more robust consultation with the United States Trustee Program, then, that's all we really need. It doesn't require any big legislative changes. It's just a subtle shift in priorities. And I don't even think it's one that really takes effort and attention away from other priorities. I think it as long as there's some information and awareness, the bankruptcy dimension of the Bureau's work can be swept up pretty naturally.
Mm-hmm. Well, so you keep really preempting. So I intended to ask you a
No,
little bit.
sorry.
No, I intended to ask you a little bit more about the sort of the process by which the Bureau would assuming they were on board, they would accomplish this. I feel like you really engaged that already quite a bit. And so I guess, and maybe you.
I have more. I can say more. I mean, that's the part of the paper that I think is really exciting, and I hope that people engage with it because, we've just sort of started scratching the surface. I mean, we can talk about something else, but
No, please. So yeah, so for people who are interested in this sort of process, right? So imagine a world where the CFPB is on board and they're like, we are. They bring you in to consult with them, right? What how do you suggest the Bureau sort of best exercise oversight over these, companies persistently engage in this sort of negative value bankruptcy?
yeah. So the thing that I'm most excited about in this section of our paper, where we really sort of set out a model for how the CFPB could go, it's probably the most boring to everybody else, but I think it has the most potential, and that's the information gathering tools that the Bureau has that really don't have a parallel in bankruptcy. So here we're talking about things like the Bureau's supervisory authority, where they can, go and investigate and ask questions of creditors who are involved in the bankruptcy process. And their manuals are publicly available and suggest that they may well be gathering this information already. So there's also the consumer complaint database that is publicly available and involves bankruptcy-related complaints. So we have this information gathering capacity. And so if the CFPB if they need to do it more robustly, great, beef that up a little bit. But more than that, if they can just share the information that they gather with bankruptcy professionals, with bankruptcy's regulators, then bankruptcy can kind of take care of its own enforcement much better than we already can. Now, that's not to say that the Bureau couldn't decide to take more targeted bankruptcy rulemaking and enforcement efforts. I think that's within the scope of their authority. And that would look like basically what they already do, but then keeping the bankruptcy implications of whatever they're doing in mind. So drafting those consent orders to make sure that they're closing escape hatches for creditors engaging with debtors in bankruptcy, and making sure their regulations are squarely handling the problem that a lot of these regulations face, which is, you want to have these companies provide information to debtors. But when debtors are in bankruptcy, that creates automatic stay problems and things like that. So if the Bureau can kind of think about that overlap and rather than ignore it or just exclude bankruptcy, harmonize the two, then they've done a pretty good job of that, I have to say, when they were doing that kind of thing.
Well, as you said earlier, this piece relates, a lot to the prior work that you've done, that Professor Sickler has done, and so we're curious, what you see going forward. Right? Are you going to continue to write in this area, or are there, threads you feel like you're going to continue to pull on in this direction? What does the future hold for you when you are a full professor?
Well, thanks, Matt. So I am branching out a little bit, just a little bit. So a piece that I'm working on my own is considering, it's going back to what most of my earlier work focused on with this problem, the role of private litigants like debtors and case trustees to address misconduct. But I am taking that into the business bankruptcy context and considering standing issues facing private litigants when they try to address some big picture bankruptcy misconduct that's playing out in business cases. So still kind of on this private litigation as a regulatory tool thing. But branching out of the consumer field. But, Alex and I can't really let our collaboration go either. We always find something new to talk about. And so we are currently trying to get a short piece out about how courts are really flubbing the analysis you need to take when you are comparing or trying to harmonize bankruptcy law and federal consumer protection law statutes. That is usually, at least with bankruptcy, and things like the FTCPA, it comes down to a question of implied repeal, whether the later statute impliedly repeals the earlier one. And the Supreme Court's been pretty clear that implied repeal is sort of a last-ditch finding. You're supposed to harmonize statutes whenever you can, and you only find implied repeal when you can't comply with both. Bankruptcy courts don't really, I shouldn't say that. Some bankruptcy courts dramatically underread that rule and overread other things, dicta in certain cases, including the Supreme Court's recent Midland funding case. And I think as a result, they're really botching this analysis. And in so doing, they're stripping debtors in their districts of a really valuable tool to address misconduct. So that's where Alex and I are, and I think we probably will continue to have a piece that we work on together, somewhere on the front, side, or back burner, because it has been a pretty valuable collaboration.
Well, that sounds great. I think it's a really, it sounds like potentially a really impactful article to help improve consumer protection in bankruptcy, and look forward to having you or Alex back on the show when that piece is ready to talk about.
Oh, thanks. Can I ask you what you're working on? I know you're the interviewer, but it only seems right.
Yeah, so I'm working on a million things, and mostly working on getting myself tenure this fall, and so putting a lot of my other projects on the back burner. But Brian Fry was nice enough to interview me for this about my bankrupting public colleges piece, which is my fourth in a series of higher ed articles, and I'm getting started on a fifth one soon. perhaps I'll be a guest on the show again at some point too.
Awesome.
Um, but you raised your collaboration with Alex, and I was really curious about that. So I co-authored my first article recently, which will be out soon in the Colorado Law Review with Dalier and Jimenez and Brooke Gottberg and Kristen Andersma. And I feel like our field sometimes thought to devalue co-authorship, and so I was really interested to hear you talk about your decision to co-author and what the obviously things are a fruitful collaboration. What do you see are the benefits of collaborating like this with Alex?
Oh, okay. So I met Alex in 2016 at the Central States Law School Association conference, which, as an aside, is an awesome conference for works in progress, not limited to law professors within the Central States. And it really started, our collaboration started because we were writing in the same areas. We realized we had a lot of overlap in ideas, but kind of different backgrounds and takes on the topic. So we thought it would be fun to write something together. And now I think, depending on how you count it, we're on our fourth project. And so, yeah, it's been great. The benefits to me, I think the biggest one, and this is something I know a lot of my female academic friends face. I don't know if you would agree with this too, but I'm pretty paralyzingly insecure about my ideas and my writing, and so the process of writing to me is really difficult. And so having somebody to work with really cuts through that noise, and allows me just to get my ideas on the paper and not worry about all the other stuff. So that's a big benefit to me. And another benefit is just, when you have to put a project to bed because something else comes up, or, you're busy with other things, it's really nice to open that document back up a week or a day later and find that somebody's done something on it. I always feel like it's, if you know that children's story, the shoemaker and the elves, the cobbler and the elves. The elves come and do all of the cobbler's work at night. That's how I feel when Alex fills in my footnotes for me. Or develops the arguments or things like that. I don't think it is really all that much more efficient, at least the way we co-author. I don't know if you have a perspective on this, because we didn't really do the divide and conquer. You write part 1 and 2, I'll write part 3 and 4, and see you at submission season. I think sort of the benefit of not doing all the writing, the time saving there has been replaced with consensus building. So, it's maybe not any more efficient, but I think it's a lot more fun. And yeah, that's the benefit of being over that tenure hurdle, which I know you will be soon. I just don't, if it's devalued in our field, or what I usually think of is people just don't know how to assess it.
Mm-hmm.
I don't care anymore. I like it. It's fun. So that's what it's been for me.
Thank you. Yeah, no, I really enjoyed the process of working with my co-authors, and I agree. It seemed no less time consuming, even though, like you said, regularly, I was on vacation when one of the turnarounds of the edits were due, and everybody else sort of pulled my weight for me in that round of edits. And I feel like various people. There's been a lot of tight turnarounds, and the law review editing schedule isn't actually very conducive. I feel like, especially with 4 of us. That they repeatedly want sort of drafts in sort of 3 days, and it's hard. It's hard for 4 people to look at things and make comments and build consensus in really short turnarounds. But I've also really enjoyed the process of working with these folks. So I hope to do more of it.
Yeah, and I think the end result has to be better, because you're basically workshopping every thought, every sentence, every footnote with a team of experts. So I think you're right. It is some of the work and especially the editorial process is tricky. Consensus building is tricky, but yeah, it's fun, it's rewarding, and I think it results in a better work product.
Yeah, no, our editors suggested that, especially in these tighter turnarounds, that one of us just be sort of delegated to make all the decisions for everybody else, and nobody actually liked that idea. Everyone will want to weigh in on the thing that's going to bear their name.
Yeah, I have trouble with that too. Just kind of ceding control. But I have started to tell law review editors, and this is also just kind of being a parent and having sort of not a lot of margin for error in my daily life. Like, look, I can do a 3-day turnaround, but I need a week's notice so I can clear the decks. So that's a good idea. We haven't gotten our draft back from Florida, which is this paper is going out in the Florida Law Review.
I didn't realize it had gotten a placement.
Oh yeah,
Congratulations. Yeah.
probably should have mentioned that earlier. So
I would have mentioned if I had realized. I'm sorry for
mm,
not mentioning it.
mm,
That's the top of the show.
no problem. So
Congratulations.
I will keep that in mind when they give us our draft back. That yeah, it's going to take a little bit longer than it might if I were the only one looking at things. Thanks for that.
So we've gone off on a little bit of a tangent from your piece in terms of sort of co-authorship, and I appreciate your bearing with. But I want to sort of bring it back for a sort of a closing question. To not that I have anything particular that I want to ask, but I want to sort of open it up to you to talk about. Is there something that I should have asked about, or is there something else you'd like to add about this piece?
There is something I meant to say now that you bring it up, and I must have gotten distracted, or it just didn't come up. But I think anybody who has listened to the end of this is probably aware that the CFPB is in a bit of an existential crisis right now. I think at last count there were 3 pending cert petitions about the constitutionality of its leadership structure. And so that is sort of, I picture it as sort of a Looney Tunes style anvil that's hanging out over our article, and we'll just kind of see how that falls. But I did want to acknowledge that we know that exists, and that we also, at least I'm not all that concerned that it's going to completely moot this article, just because, my read of the tea leaves is that even if the court grants cert, and even if the court finds that the CFPB's leadership structure is unconstitutional, they are not going to throw out the entire Consumer Financial Protection Bureau. Instead, the remedy will be, as many lower courts have found, the appropriate remedy to sever the unconstitutional provisions from the remainder of the statute. And so, I think it's just worth mentioning before we let this go that, that's hanging out there. It's given us a little bit of heartburn, but chances are good that it won't actually disturb our arguments all that much.
So I'm not particularly a court watcher, but my understanding is that Justice Kavanaugh, when he was on the circuit judge, had one of these cases, and that was the remedy that he suggested.
Yes. Yeah.
My view sort of largely aligns with your own too. So.
Yeah. So let's hope so. Otherwise, this is hope. Well, at least it's accepted. I know I shouldn't say that, but I'm hoping that this paper actually has the ability to do some good, and it would be a shame if that were otherwise.
Well, thank you. I'm teaching a consumer law seminar at Howard this year, and things I say to my students when they're sort of picking topics is, you need to pick a topic that you should pick a topic that you're passionate about, that you're excited for, that you hope will make a difference in the world, because you could write about anything. One of the joys of being a law professor is defining the problems we work on and proposing solutions. And so, I'm glad you found sort of a vein that to mine that is brings you joy to sort of think about and work on. And it's been really a pleasure to talk to you about this article tonight.
Thanks, Matt. It's a pleasure to be on the show, and I appreciate you reaching out.
Well, thanks so much, and I'll look forward to talking to you again when the next article is ready.
Sounds good. Thanks, Matt. Have a good night.
This is a song to celebrate banks, because they're full of money and you go into them and all you hear is clinks and clanks. Or maybe a sound like the wind in the trees on the hills, which is the rustling of the $1,000 bills. Most bankers dwell in marble halls, which they get to dwell in because they encourage deposits and discourage withdrawals. And particularly because they all observe one rule which woe betides the banker who fails to heed it, which is you must never lend any money to anybody unless they don't need it. Oh, you cautious conservative banks, what I know about you. If people are worried about their rent, it is your duty to deny them the loan of 1 Confederate sou. But suppose people come in and they have $1 million and they want another $1 million to pile on top of it. Why, you brim with the milk of human kindness and you urge them to accept every drop of it. And you lend them the $1 million, so then they have $2 million, and this gives them the idea that they would be better off with 4. So they already have $2 million as security, so you have no hesitation in lending them 2 more. And all the vice presidents nod their heads in rhythm. And the only question asked is, do the borrowers want the money sent, or do they want to take it with them? But please do not think that I'm not fond of banks, because I think they deserve our appreciation and thanks. Because they perform a valuable public service in eliminating the jackasses who go around saying that health and happiness are everything and money isn't essential. Because as soon as they have to borrow some unimportant money to maintain their health and happiness, they starve to death, so they can't go around anymore sneering at good old money, which is nothing short of providential.